Ask an attorney about Florida law. Ask an attorney, just give him a call.
This is Ask an Attorney, all about Florida law with Attorney Joe Pippen. If you have a legal question, call Joe right now. In Tampa, call 813-287-5700. Anywhere else, toll free at 877-943-9673. That's 877-943-9673. The law office is open. And now your host, Joe Pippen.
Hey, good morning. Welcome to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. The law office is open. Hey, that means you can call in if you have a legal question or problem. I'd be glad to try to help you. That's what we're here for today, just helping as many people as we can. Your question that you ask may help other people listening as well, so hopefully I can help you and help others at the same time. If you have a legal question, it can be about wills, trust, probate, trust administration, can be about power of attorney, healthcare, surrogate living wills, can be about marital law, can be about real estate law, can be personal injury. Just any legal question you have, I would love to be able to try to help you. The toll-free number is 877-943-9673. That's 877-943-9673. You're also watching, if you're on Facebook Live today, we do Ask an Attorney Facebook Live every other week or so. We do a live show, so if you want to turn into Ask an Attorney, we have an Ask an Attorney page. We have a Law Offices of Joseph Pippen page. We have the personal page if you're there. If you want to watch on Facebook Live, hey, I would love to have you do that. If you want to send a question, we even have resources now to where we can see your question on Facebook Live and answer that as well. If you'd like to call in, though, that's the most common way people call the show, is the 877 toll-free, no matter where you are, 877-943-9673. Every week we're here trying to help people. A lot of questions we get concern estate planning. I was asked this week, what's the most often asked question you get on Ask an Attorney over the years? Started broadcasting in 1984. I think it's the longest running continual program in Florida. I would say the most often asked question deals with person moves to Florida or is relocated to Florida maybe recently or some time ago, and they have out-of-state documents, and they want to know if their out-of-state documents will be valid in Florida. Well, that's a concern. You want to make sure your documents are up to date. You want to make sure your documents are going to work wherever you are. The answer to that is most likely they're valid. However, they need to be reviewed. I get questions like that, and I don't really know if the person did it themselves, if they did it online, if they had an attorney do it, a paralegal do it, a next door neighbor do it. There are many different ways to get documents done, so if I just automatically assume that an attorney did it, that doesn't even totally answer the question. Was it an estate planning attorney? The laws might be different in the state that you moved from than Florida. The laws are different about witnesses and notaries, and there are a lot of different ways to look at it. So a document really needs to be reviewed. Most of the time I would say would be a valid document, and better, it would be a valid document in Florida, but it could have been done better, or if you redid it in Florida with a codicil or a change to the will. And by the way, do you know that your will, whether it's drawn in Florida or some other state, is going to go through probate if you die with an asset just in your name? So those are all things to talk about. We have Thomas calling from Tampa. Good morning, Thomas.
All right. I bought a house just over a year ago today. Within 3 months, my roof started leaking. I didn't know it until 4 months later because there was another major leak. They came out and fixed it, but within the next rain, it started pouring in my house again.
Is this a brand new house or?
Yes, sir. Yes, sir. Lennar Builders. Yes, sir.
Okay, so you got a warranty with a new house.
Yes, but now I'm coming up to my 1 year. Well, my 1 year warranty's over, but they're still doing repairs from like 5 months ago, if you can understand what I'm saying. And they're telling me they want to extend their work that they're doing for another year or anything like that.
Well, hey, have a warranty, have a roof inspector come out and make a list of what needs to be done. Make sure you get it to them that before the year's up, and tell them you're going to hold them accountable. I had to pay for a roof inspector. I think you should pay for that too. Here's a list of the problems with the roof on a brand new house, and I expect my roof to be just like if it were new, and I'm holding you accountable to fix it.
Okay, I appreciate it. I was definitely thinking about that. They're telling me they have like 100 in the development. I'm like, what kind of answer is that? You know, brand new.
Well, they might have 100 problems.
Yes, sir.
I would find a roof inspector and then tell as many people as you're friendly with there, or maybe everybody if you could, that you really need to have your roof inspected because you could have the same problem that I do with this builder.
Yeah. One was leaking for 3 months, the one guy told me, because there's already mold there. But I didn't even know about it 3 months prior to I discovered it.
Hey, you should be a good neighbor and go tell everybody about your problem. Everybody should really have their roof inspected and hold this guy accountable, or guy or gal, whoever it is.
I will definitely take your advice. Thank you very much.
All right, thank you. You're listening to Ask an Attorney, all about Florida law. Again, I'm Attorney Joe Pippen, practicing attorney. Law office is open. All you have to do is to dial our toll-free number, 877-943-9673. Phone lines are open, and love to help you if I possibly can. All you have to do is to dial that number. So what is the second most often question that I've gotten over the years on the radio, doing radio? Probably people talk about trust a lot, living trust a lot during my shows, and a lot of people have questions about wondering. In fact, I was doing seminars this week, and you have a little question and answer period at seminars. They always want to know, well, what's the difference between a will and a trust? Hey, how come a trust avoids probate, as you say, but a will doesn't? Aren't they just two different types of pieces of paper or documents? Why does one avoid probate and the other one doesn't? It's really a simple answer. If you have a will and you die, you're going to die with assets just in your name. When you have a living trust, you can tell by the name of the document that when you create a living trust, so you create it while you're living, but when you die, the living trust is still living, and the assets inside of that trust don't go through probate. So if you do a living trust, you pay just a little bit more. It's not even that much more in cost, actually. But you get the big benefit of no probate, no guardianship, quick, easy, fast, efficient, being a private document. You get a lot of advantages to a trust that you don't get with a will. And it's just a different document. You have a choice in how you create your documents. You can create a will, but you need to know you're creating something that's going to go through probate if you die with an asset just in your name, or you can create a living trust and you can choose to create a document that avoids probate. I have people all the time tell me, well, I don't want to go through probate. My family member died. My mom and dad died. Brother, sister died. Probate was horrible. Probate lasted a long time. I couldn't believe what they charged for probate. Probate's very expensive. And you can do that, avoid probate with a living trust. All right, let's go to Al in Sarasota calling. Hey, Al. Al, are you there?
Trust.
Okay.
Are you there?
I'm here. Go right ahead,
If I were
sir.
to create a trust and place my home in the trust,
Yes.
and then in the future, if I wanted to do a reverse mortgage on the house, is that possible?
Yes, sir, it is. You can create a trust. What I do when I'm doing this for a client is to put their home in the trust. We do what's called a quitclaim deed. So we do a deed, we transfer the property to the trust. We don't have to record the deed, which most people don't. Your successor trustee can record the deed into the public records when you die. You own the home. When you put it in a trust, you still own the home. You and the trust are the same entity, the same tax number. So there's no loss of homestead exemption. So the lender doesn't need to know that it's even in a trust or you've done a quitclaim deed. And if you felt like you needed to tell them and they would object to it, you could easily just tear the deed up and then redo it after the reverse mortgage was done. But most people, it's not a problem.
Gotcha. So the quitclaim deed is never really filed. It just remains in the trust until death occurs.
That's one way to do it. That's one way to do it, and that's what most of my clients do. Yes, sir.
Okay. All right. Thank you very much.
All right. Thank you.
Bye.
All right, that call came from Sarasota. I was down in the Sarasota yesterday area, down at the University Mall. What a great mall that is. That's a beautiful mall. It's one of the better malls we've been in here in Florida. I guess they had to build a mall for all those residents in Lakewood Ranch. That's a booming development. We do have an office there in Lakewood Ranch, by the way. All right, you're listening to Ask an Attorney, all about Florida law. If you have a question, you have a toll-free number, 877-943-9673. Phone lines are open. Let's go to Robert in Clearwater. Hey, Robert.
Yeah, this is Robert from Clearwater. I trust people's trust insurance, and a neighbor's tree fell in my yard and broke my whole fence. I mean, it's huge. I mean, it's gigantic. I mean, this stuff is hanging there. I'm afraid I'm going to get hurt. Plus, my gate is messed up from the hurricane. I think my pool is leaking because it went down a little bit. I had the insurance adjuster came and take pictures and stuff, but nobody came back to get in contact with me. He said someone's going to come back. With that person's tree that fell in my yard, would your homeowner's insurance cover my fence all the way around and take care of that big tree? Is that like a lot of damage?
No, your insurance would have to take care of the damage to your house.
My insurance would have to take care of it.
Yeah. Unfortunately, I don't like that law. If I could do something to change that law. But you have a hurricane, you have the active nature, basically. Right. So you can't hold a neighbor responsible for a hurricane, even though it was his tree.
Right.
But I think the law should be changed. Like, I've got an overhanging tree on my property right now. I know the next hurricane comes by, the tree will probably snap off like some of the other trees my neighbor had, and do cleanup costs, fence costs. So if I saw a tree that was in danger of someone else's property, I would fix it. I would be a good neighbor. I would feel responsible and I would fix it. There's some neighbors that just don't have that same attitude, and they have okay, I've got a tree, but it falls on your house, it's your problem. And they know there's a possible danger and don't do anything to fix it. I don't think that's really a good neighbor, is my opinion.
Yeah, because I could get killed over it. That's how bad this thing is.
Absolutely.
It's large, I got a bad knee. I got to get operated on my knee because I actually fell close to the hurricane, but it was dark out, and I really hurt my knee even more. But, yeah.
Yeah, I think what you should do, too, I think you should send your neighbor a letter. And call it I'm putting you on notice letter that
right.
You have a dangerous tree that could cause damage to my property, and maybe even my life. And I'm holding right. you accountable to take care of this and fix it before that would happen. And I'm going to go show this letter to all of your surrounding neighbors and encourage them to write you the same letter. You need to be responsible for your own trees, regardless of what the law is. That's right, what I would do.
I agree 100% because it is dangerous. I got to get a whole knee replaced. I can't even walk anymore. I mean, it's terrible.
Yeah.
I walk with a cane just to walk up the street. I mean, and then on top of the hurricane, I fell in my house because it was dark out. You can't see because it's dark, But it's terrible. I just wish somebody would do something. I'm waiting for.
I think the best thing you can do is to put the neighbor on notice.
I'm going to do that. Thank you, sir.
Yeah.
I appreciate that a lot. That's
all
a good
right.
station you guys got.
Thank you.
All right. I'll let you go. Bye-bye.
Thanks. All right, you're listening to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. The law office is open, and we're open on Saturday mornings, and we do Facebook Live. We do Facebook Live about every other week, sometimes a little bit more than that. But if you have a legal question, if you could watch us on Facebook Live, that would be neat. If you want to join my Ask an Attorney page, you can try to do that online on Facebook, or you can send me an email, joe@attypip.com, and I'll send you a link. We'll make it easy for you. So joe@attypip.com. You can also watch Ask an Attorney on WeBeam TV. That's just WeBeam, BEAM, and TV.com. And they host several shows in the past as well. And also we have a little YouTube channel going on now with hosting, with showing the shows. But if you want to watch the show or watch a previous show, you can certainly do that on one of those methods, and we'll certainly send you a link if you want to contact me at Joe, Joe, at attypip.com. Also, I think we're going to start posting some of the better questions we get weekly on Ask an Attorney, and maybe some even by email if they're outstanding questions that I think would be helpful to lots of people. We certainly get those once in a while. All right, let's go to Jeff in New Hampshire. Hey, Jeff.
Yes, good morning, Attorney Pippen.
Yeah, so how are you? Are you watching us or listening to us, and where from? You're from New Hampshire?
Yes, I'm watching you on Facebook as we speak.
All right. Well, great. What can we do for you?
So my question had to do with living trusts. You had spoken about that a little while ago. My understanding, and please correct me if I'm wrong, is that a living trust is like a separate entity. In other words, I'm an entity, a person. So are you. A living trust, a trust is another entity, and it seems to be that as people do estate planning, their goal is to put all their assets under the ownership of the trust, so they cannot be basically attacked by creditors. Is my understanding correct?
Well, not exactly. And first of all, let me say I'm not licensed in New Hampshire, so unless you're a Florida resident, you probably need to get the advice of a New Hampshire attorney.
Understood.
All
yes,
right.
I have family in Florida. That's why
Okay.
I have my interest.
All right, a living trust, when I create a living trust for myself, and I'm using just myself for an example in this question, the living trust has my tax number, my social security number. My trust and myself are the same entity. So I'm not creating a different entity with a different tax number. And I can put my house into the trust. I can put my financial accounts in the trust. I can put whatever I want to in my trust. It needs to go in my trust. When I pass away, just like my estate would be a different entity than me because I'm deceased, and then if you pass away with a will, the estate would be a different entity. If you pass away with a living trust, the trust at that point would be a different entity. Now, you mentioned the word asset protection along the way. The trust, you can create what's called an irrevocable trust, which would be a different entity. Now, most of my clients don't do that. And if you're talking about asset protection for an elderly person that wants to get on Medicaid, there's a 5-year look-back period on an irrevocable trust, which is a different entity. So there are all kinds of trusts. Most of the time we're talking about living trusts on the show. They're a living trust. You and the trust are the same entity. It's not a different entity. It has your same tax number. There's no extra tax record keeping. There's no extra tax return for the trust. You and the trust are the same entity. So does that answer your question?
Yes, it does. Thanks very much. So what I was referring to, I guess, was an irrevocable trust, which, as you said, is not all that common.
Yeah, it's for a special purpose. People used to do it so they wouldn't own anything, so they could apply for Medicaid. So they tightened up that rule and made a 5-year look-back period now. It used to be a 3-year look-back period. I mean, so it's changed along the way, but you can't own assets one day, create an irrevocable trust, put them all in there, then they're still countable assets up to 5 years look back.
Understood. Thanks so much.
All right. Thanks for calling. Thanks for watching on Facebook.
My pleasure.
All right. You're listening to Ask an Attorney, or maybe watching Ask an Attorney, all about Florida law. If you have a legal question, you have a toll-free number, 877-943-9673. That's 877-943-9673. Phone lines are open. Let's go to Roger in St. Petersburg.
This is Roger Kelly. I would like to set up an appointment with Mr. Joe Pippen in reference to a very intense legal situation with my insurance company. My house burned down, and they tried to foist a one-bedroom house on my property after assuring me I would have my house replaced. It's gotten extremely nasty.
All right, Roger, do you have access to email?
No, I do not. What I need is a local phone number for your office, and I called up I had an old phone book, and I called up, and they said the number was disconnected. I have your phone. I've been listening to you for over 20 years.
All right.
So what?
All right,
So
so
I,
well,
I
thank
need
you so
some
much.
definite advice.
All right. Let me give you my phone number. Make sure you have the right number. It's 727
Hold on, 727
586
586.
3306.
Make sure you have the right number. 727.
Oh,
can you-
727-586-3306.
Yeah, extension 200.
What's that?
Extension 200. The young lady will take a message, and I will give you a call.
Okay, 727-586-3306, extension 200.
Yes, sir.
And I can set up some sort of, where is that office
All right, well, I'll
located?
probably give you a call and talk to you a little bit. I'm not sure I would be the one, but I do have, if I can't help you myself, I do have a good referral that deals with insurance matters.
Well, I called another law firm, and I got a novice kid, and he went through a script, and I said, look, you're
No.
reading a script. And it went on and on forever.
Yeah.
And we got cut off. My phone is sick.
All right, sir, I have a great referral experienced attorney that deals with insurance matters. I would probably talk to you a little bit and make sure I would think he can handle the case and give you the number.
Okay, then I'll call your secretary and make an appointment.
All right, Roger.
Thanks. Good talking to you. I got you
When
on right now. That's what the noise is. You're on my radio.
All right, thanks so much.
Okay, Joe. Take it easy.
Thank
God
you.
bless you.
Let's go to D in Winter Haven.
Hi there. Thanks for taking my call.
My pleasure.
I'm a homeowner and have been the sole owner of it for 20 years. Two questions that go with that. I got married 7 years ago. One, if I refinance, under the understanding in Florida that I have to put my husband on the title. And the second question is, if I would divorce, what percentage does he get out of the house, or is there something I can have signed that wouldn't happen?
All right, well, first of all, you can, since you're married now, I assume you don't have a premarital agreement.
Correct.
So since you don't have a premarital agreement, you can agree both to a postmarital agreement.
Okay.
If you have a postmarital agreement, he could waive his right to your house.
Mm-hmm.
He could waive his homestead right. And then once you show that postmarital agreement with him waiving his right to the homestead, the mortgage company, I think, would allow you to do the mortgage just in your name and not have his name on there.
Okay.
All right, but to answer your question, if you do not have a postmarital agreement, or he's unwilling to sign one, then they're definitely going to make him sign on the mortgage. Maybe not the deed. But if you die without making a provision for him concerning the house, his statutory spousal right is he could sell the home and take half of the proceeds, or he could take what's called a life estate and live in the home for life. And that's why the mortgage company is going to want him on the hook on the mortgage as well, absent a postmarital agreement.
Oh, I see. Okay. So with no marital agreement at all, then, if we did divorce, then what percentage would he get currently? Is it automatically half?
On the house, he could sell the house and take half the proceeds or live there for life. On the rest of the estate, he has a spousal interest of 30%.
So there's not a year, like so many years. If it's 6 years, you only get a percentage. If it's
No.
7 years, it's okay. All right.
No, well, that pertains to divorce. There are rules about if you're married less than 17 years, there's a 7 year.
That's what I'm looking for.
In 17 years, but that's divorce.
Yeah, well,
That's
the
not
second
an
question was,
estate.
if I did divorce currently and I'm the sole owner and he's not, because I haven't refinanced, so he's not on the title, he's not on the mortgage at this point. If I did divorce and we've been married 7 years.
I can't give you really an exact answer on a divorce because that's like cherry picking one asset and trying to tell you exactly what's going to happen to it. The divorce is much more complicated than trying to give that to you. There are so many other factors that go into who's entitled to what upon a divorce.
Right.
So the answer
Yeah,
I gave you dealt with your estate, but not the divorce. I probably have to get you to talk to our family law attorney a little bit to maybe try to hone in on a better answer on that, but it depends on lots of questions that would have to be asked.
Right. It's just amazing you can own a home for 20 years and pay on it and then be married for 7 years and they take half of it. Wow.
Well, that's why you need a pre or postmarital agreement on a second marriage a lot of times.
Thank you. The postmortem agreement is very smart. All right. Thank you so much.
All right, thank you. You're listening to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. If you have a legal question, you have a toll-free number, 877-943-9673. That's 877-943-9673. Phone lines are open. If you want to watch the show on Facebook Live, well, you can do that on the Ask an Attorney page. You can do it on Law Offices of Joseph Pippen page. You can do it on my personal page. I think it might be just a general feed on Facebook, but I think that's sometimes hard to find. I'm not sure how that works. You could watch it on WeBeam TV Live. If you can't get it because you're not a member of Ask an Attorney. In fact, you can send me an email and we can send you an easy link to get to that Ask an Attorney page if you want. You can go online to www.webeamtv.com and they have a live version of the show as well. Plus some of the other shows on their network, Ask an Attorney shows. Plus you might find some other programs on there you like as well. Let's go to Nancy in St. Petersburg. Hey, Nancy.
Hey, Joe. I want to thank you in advance. I've been listening to your show, and I've learned a lot about trusts and wills and the difference. And one situation with me is that I did go out and after I bought my house and immediately got a will, thinking that was going to protect my assets and be, transferred over to my daughter when I passed away.
Mm-hmm.
And listening to your show, I now understand that's not the case. So I'm probably going to be coming into one of your offices and looking at a living trust. One of the question I really have for you today is in regards to a power of attorney. I understand that a power of attorney basically dies with you. Is that correct?
Correct. It becomes invalid upon death.
So what kind of a document do you need to have, does the individual survivors need to have in order to be able to do business in your name after you pass away?
Oh, the living trust that we were talking about takes care of that because your successor trustee that you name in the document has the power to deal with all of your assets that are in the trust.
So it takes care of everything, pretty much, and it avoids probate.
Yes, it avoids probate of all the assets you put in the trust. You have a will that leaves assets to the trust that you didn't put in the trust that you should have. And things like personal effects, your personal representative can deal with those without going through a probate process as well. Some assets you have like retirement accounts, insurance and annuity products that have beneficiaries can be dealt with outside the trust, and all you need is a death certificate to be able to deal with those.
Yeah, I have my daughter as my beneficiary on my bank account and on my life insurance and all of that, but the house was the main concern.
Mm-hmm.
I know that you can't speak for other attorneys, but just for the heck of it, why would I go to a family planning attorney and tell him what my objectives were and him suggest me doing a will when a living trust would have definitely been a better document?
If it's a family law attorney, they might not be fully aware of all the benefits of a trust. Some attorneys would take the position that probate is better. I mean, I would never agree with them, but they would argue that you need the court supervision dealing with estates. I've heard lots of reasons why people might say that, but, I think that I've had a debate one time that was televised with an attorney that was pro-wills and probate versus what I was saying trust was better. They're just different opinions on different attorneys.
Yeah, well, it looks like the trust would probably alleviate you having to go back to an attorney, whereas a will is a guarantee that you're going to have to go back to an attorney.
There you go. You nailed it.
All right, thank you, sir. You do a great service to all of us, and I really appreciate it, and I'll be calling your office because I need a trust.
All right, I look forward to meeting you.
Thank you.
Thank you. You're listening to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney and host of Ask an Attorney since 1984, and glad to be here. It's fun helping people understand things and fun just helping people in general, I think, for me anyway. All right, let's go to Nancy. We just talked to Nancy. Let's go to Al and Brandon. Hey, Al.
Yeah, it's actually Ali.
Ellie, okay?
Yeah, Ollie, yeah. So, quick question. My question would be if I have a friend, and currently there's a injunction, or protection of an injunction of a domestic injunction has been filed against them. So, and get it taken care of and file a motion to have that injunction dissolved or vacated. Now, when you file the motion, and they say you have to file a certificate of service, do you file the certificate of service with the court first, and then take a copy of that to the sheriff's office and have them file the individual, or do you have to take that certificate of service to the sheriff first, have them serve it, and then file it with the courts?
Well, you need to prove to the court that it was been filed and received by the person. So the receipt that you get from the sheriff, along with a copy of it, should be filed after it's been served on the person.
Okay, so you would draw the motion up, take it to the sheriffs with the certificate of service, have them serve the person. Now, do they automatically send you some sort of receipt that it has been served so that you can serve it with the courts?
Well, when you take it to the sheriff, ask them, to send it back to you, maybe even give them an envelope.
Okay.
To send it back to you, and that should work.
All right, do you know how long that normally takes?
It depends on how long it takes them to find the person to serve them, basically.
Gotcha.
All right?
Okay, got it. Thank you, sir.
All right, thank you. You're listening to Ask an Attorney, all about Florida law. We have about 20 minutes left in the show. You have a toll-free number. You have a question or a problem, why worry about it? Give me a call. Maybe you lost a little sleep last night over something. Hey, I'd love to help you. 877-943-9673. Phone lines are open, and let's go to Larry in Jacksonville.
Deprived. I wanted to ask a question in regard, and I don't know if it's your area in a divorce case.
Mm-hmm.
I have a residence in Georgia.
Mm-hmm.
Okay, substantial acreage, and there is my wife is the sole owner of a residence in Florida.
Mm-hmm.
In the event of a divorce, she is wanted to trade, which I'm definitely not. It's not an even trade, obviously. And I wanted to how would that be determined? There's no prenup, no, I'm not going to get her to sign a post.
Mm-hmm.
So would that be up to the judge, basically, or?
Yeah, the court would take a look at all of you both have to file financial affidavits with the court.
Right.
With full disclosures of all assets. How long have y'all been married?
It's a long time.
A long time?
More than, about 30 years. It's long. It's long.
Well, a lot of times when you're married that long, there's a pretty equal division of the assets.
Yeah.
Especially those that were acquired during the marriage.
Okay.
So basically, you just need a family law attorney that can walk you through and help protect most of your assets.
This is two different states, so
does she live in Georgia?
Currently, here's the deal. She's watching her mother,
mm-hmm.
who is elderly, over 80,
mm-hmm.
and I'm thinking they may weigh in her favor due to that fact. It kind of gets involved. In other words.
No, I don't think caring for the mother is necessarily going to play a big factor in the divorce proceeding.
Okay, I'm just. If
y'all could agree, the best advice I could give you is you two sit down and work out something. If you're going to save a lot of time and money. If y'all can agree on how things will be divided up, that can be turned into a property settlement agreement.
We haven't been together in 30 years, but that doesn't have a thing to do with it. I mean,
but if y'all can agree on how to divide things up, you're going to save a lot of time and money.
A whole lot easier.
Yes, sir.
Like I said, cheaper to keep her. I didn't say that. Okay, I appreciate it, Joe.
All right. Thanks. All right, you're listening to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen. Phone lines are open, and if you have a legal question, it's 877-943-9673. That's 877-943-9673. Let's go to Tony in Littleburg.
That is Middleburg, Florida, just south.
Middleburg. I know where Middleburg is. Actually, all right. So what can I do for you? I see the sign to Middleburg as I drive to Jacksonville on my trips there every other week or so.
Okay. Yes, my question has to do with one of my sons. He's in the military, so he has Florida as his home of residence, but he owns a home in another state. And I guess my question is, would he need a trust for that home to be wrapped in and covered under Florida residency, or how would that work should he pass while on?
All right, so he's a Florida resident?
Yes, sir.
And does he own land in Florida?
No, he does not.
Okay. Well, a Florida resident can create a living trust, and they can put real estate in other states in the living trust to avoid probate both in Florida and the other state. So I think it would probably be a good idea, just based on you'd save the probate costs in the other state. And he might need 2 attorneys. He might need a Florida attorney for a Florida probate and an attorney in the other state to probate the land in the other state.
All right. Well, thank you, Mike. That answers the question.
All right. Thank you. You're listening to Ask an Attorney, all about Florida law. If you have a legal question, it's 877-943-9673. 877-943-9673. And let's go to Andre in Winter Haven.
Good morning.
Hey, how are you?
I'm fine, thank you. I have a question. If I have a friend who recently lost her husband. Both of their names were attached to a property.
Mm-hmm.
Since he's deceased, his name remains attached as well as hers, but it's now in the estate of.
Okay, hold on. So the names on the deed must have been without any magic words after their names, like jointly held with right of survivorship or anything like that. Because if there are no magic words, I'll call them, after the names, then it's tenants in common. So tenants in common means that his half would be in his estate and her half would still be owned by her.
Okay. So in order for her to get him off, would his half go in probate?
Yeah, his half would go in probate. Yes, sir.
Okay. Okay, so she would have to go through all the legal aspects in order to even try to remove his name.
Yeah, did he have a will?
I'm not sure if he had a will because she didn't really disclose that with me.
No, they were just friends. They weren't married. Is that correct?
No, they were married. They were married.
Oh, okay. Well, let me ask you this: if it had his names, comma, his wife on the deed, then that would mean tenants by the entirety, which means that she would be the sole owner at this point.
Okay.
And even if it didn't have the words his wife, there's probably an affidavit of continuous marriage that can be filed that could possibly fix the problem to where she would be the owner without a probate.
Okay.
So I think she would need to see an attorney to make all that happen if possible. And also looking at the deed.
Okay. I will certainly pass that on to her.
All right. All right. Thanks for calling.
Right, thank you.
All right. We have about 12 minutes left in the show. You have a toll-free number, 877-943-9673. Let's go to Kevin in Brandon or Bradenton. Which is it?
Bradenton.
Bradenton. All right. What can we do for you?
Hey, good morning, Joe, and thank you for all you do spending your Saturday mornings. I enjoy listening to you. And your planner. I like that planner you have, too.
Oh, great.
I just wanted to bring up, I've had a trust for years, even though I'm never going to die, so I probably won't need it.
Are you going to be raptured?
Yeah. But,
all right. Well, hey, that's a good plan if you can make it work.
If you have any assets, my understanding is, it's a lot cheaper. It costs more to do a trust, but in the end run, it costs more to do a probate if you have much in assets, and maybe you can elaborate on.
Well, okay, well, I disagree. I disagree that it costs a lot to do a trust. Here's my example I like to share with people. if you were a married couple and you came to see me and you were your goal was to get wills done, so I'll talk to you about wills a little bit. Wills are $125 each. Most clients that do wills do power of attorney, healthcare surrogate documents, and living wills. And the fee for those 6 documents is $620, but you pretty much guaranteed yourself of some probate somewhere. If you do a living trust, the fee includes all of those documents plus the trust plus the deed to your house, and it's $795. So you pay $175 more to do the trust package, but you avoid probate, which is thousands of dollars. So it doesn't cost that much more.
Yeah, you're right. It's a bargain in the end run that people don't realize how expensive probate can run if you own property in a house.
Yeah, exactly.
Assets. So it's really a bargain, but people.
Well, thanks for giving me the opportunity to share my prices on trust.
And then you get into. I had my good friend's mom passed finally, but she did her own health care directive and did it wrong.
Right.
And had a stroke. Didn't mean to be kept alive. They kept her alive for 3 years, and it's not what she intended. But she and the neighbors got together and did one of these do-it-yourself deals, and it didn't turn out well.
You got it.
All right. Well, thank you again for all you do.
Well, hey, thanks for calling. It was nice talking to you. All right, thanks. All right, if you have a legal question, we have less than about 10 minutes left in the show. You have a toll-free number, 877-943-9673. And we're going to go to Laura in Pinellas. Hey, Laura.
Hello, sir.
How are you?
Good, thank you. I'm calling to ask you why a lot of attorneys don't think co-executors is a good idea.
Well, I'm not sure they think it's not a bad idea. If you have a single person, they can operate by themselves. If you have co-executors, then 2 people have to sign everything.
Yes.
So if they don't live in the same city, that could be a hassle. If they don't live close to one another, that could be a hassle. It could be a hassle if they don't agree on things. Usually,
right.
So if you have one person, then they have a duty to follow the instructions of what the will says to do, which generally is to pay my bills, pay the taxes, pay the creditors, and then make a distribution according to the terms of the will. So it's easier, I would say, for one person to do it, but sometimes family members want a little check and balance and have both kids that they love equally and want to share the responsibility equal.
Sounds like you know me. And I keep coming back to Mark Twain. Mark Twain said, you never really know a person until you share an inheritance.
You got it. I tell people that all the time.
Yeah, and I've been, personally I was burned by a sister, so not saying my kids would do that, but I just want to make sure that wouldn't happen again.
Yep.
So I think I would choose for co-executives.
Yeah, well, the other thing, as I'm talking to clients about this, if you name co, then you put the burden on them to decide how they want to work.
There you go.
Do they want to torture one another or make it easy and get it done, basically?
That's exactly right. And if they're both living out of state, it's not like it was that one child lived in Florida, so if they were the executor.
Yeah.
But now that both are out of state, I said, what the heck?
I actually had a client one time tell me they wanted to get revenge on the kids, so they were going to make all 4 co-executors.
That's interesting. I wonder how that worked out.
Yeah.
Well, thank you very much,
all right.
sir.
Thank you so much for calling.
Bye-bye.
All right. You have a toll-free number and about 6 minutes left in the show. You have a toll-free number, 877-943-9673. Phone lines are open, and we're going to go to Cynthia in St. Petersburg.
Good morning, Attorney Pippen.
Good morning.
Thank you for taking my call. I was calling because I have a problem, and I don't think it's going to take. It's going to take quite a bit of your time, probably. But so I don't know how to talk
actually,
to
Cynthia, I'm not going to let you take a whole lot of my time because I only have like 6 minutes left.
I was going to just ask you if if perhaps when I tell you a little bit of it, that maybe I could call you and you may be able to help me out or find me in what I need to do.
All right.
Because my father passed, and he had a lucrative roofing business. And because I'm on disability, my brother was over executor, I guess, over the estate.
Right.
And my father left or had a will, but he left it. It was so messed up, and he didn't. He left each of us $10,000 in cash, and he had many cars and many properties and everything. But he left my brother in charge, and nobody got their $10,000, which would have been equivalent to $70,000 with my adopted sister and my.
Okay, Cynthia, let me tell you this. What you need to do is make an appointment. If you haven't gotten I think the where you're going with all this is you haven't gotten what you thought you deserved to get from the estate.
Well, what happened? That's over. He didn't give us a probate, a mention of the probate or anything. That part is over. Now they're fighting with a lot of property that was left my father before he passed, and he was over the administrator over the property, and then it fell in my brother's hands. And the property is in Georgia. It's a lot of property, and it's supposed to be, very, very expensive. Lots of money. Some of the people in Georgia, that's part of the
Hey, Cynthia, I've got two other calls I need to get to. So I think the best thing for you to do is just to call me, and then I can talk to you privately on the air and try to give you some advice.
I would appreciate that so much, Attorney Pippen.
All right, thanks.
Will you do your number?
Yeah, I will. I'll give the number right out at the end of the show. Sure.
Oh, thank you so kindly.
Thank you.
Okay,
all right.
Have a great day.
You
Bye-bye.
too. Bye. Let's go to Carol in Tampa. Hey, Carol.
Oh, good morning. Good morning, Mr. Pippen. I'll make this real quick. Before Hurricane Irma, there was no reason for this tree to come down, but you can't.
Was the tree on your property or a neighbor's property?
Okay, it's on a neighbor's property. It closed the whole road. They had to get heavy equipment in to cut it up. Well, part of the tree took out my fence. And the house is up for sale. I called the realtor. She said, we'll get back with you. She never did. And I just wondered, do I need to have an attorney? Well, first of all, the tree is on their property. It damaged my fence. Do I need to have them get my repairs done on my fence?
No, it's going to be up to you and your insurance company.
You're kidding.
Nope, I wish I was.
Oh, my goodness. No wonder they haven't gotten back to me.
Yep. Yeah, some neighbors, you can make the neighbor morally, ethically responsible, perhaps, but the law is on their side. A hurricane, act of nature, falling on your property, even though it's his tree, your insurance company, and you pay the damages.
Oh, my goodness. And yet I own a piece of property over in Brevard County, and a lady sent me a letter, a neighbor. It's just an empty lot, but her house is next door to it. And she sent me a letter, and I had to send a whole crew over to Brevard County to take down a bunch of the trees.
Well, you may not have had to, but that's being a good neighbor, so, good for you. But
well,
you might not legally, you might not legally have had to.
Mr. Pippen, you're a wonderful gentleman and
thank you.
A wonderful lawyer, and thank you.
Thank you so much for calling.
Thank you.
All
Bye-bye.
right, thank you. All right, let me give you my contact information, and we have one more caller I'll try to get to. So if you want to call the office and make an appointment, it's 727-586-3306. That's the office number. Toll-free office number, 1-800-226-3529. If you want to email me, it's joe@attypip.com. If you want to email me for any reason, it's text me at 727-667-3967. So the phone number for the local person that there wanted to call me is 727-586-3306. Go to extension 200. Let's go to John in South Florida.
Yes, sir. Thank you for taking my call. I've got a tenant who missed the payment last October of 2016. I did verbally advise her and sent her written notice that she was and she did confirm that she had no record of the payment. And I wasn't pushing it because she was in
Hey, John, call my cell phone in about 10 minutes, and I'll be glad to talk to you. 727-667-3967. All right, hope you got that. All right, thanks for listening to Ask an Attorney, all about Florida law, every Saturday morning, 8 o'clock. Glad to be here. Hope I helped you, and you have a great weekend.
House